Good morning to both of you. Mr. Egan, I'll start with you. Again, are you contesting or disputing anything in this case, sir?
I don't think I can I?
Excuse me?
I don't think I can in any way, can I?
Well, you can always contest or dispute a case. I don't know what you've done in the past as far as if there's been a default entered or what. So you'd have to take care of that if that's the case. So it's up to you, sir. I'm just asking.
No, I think I'm just gonna...
Okay. And ma'am, do you have the script that we would have provided to you?
Yes.
You can go through that now. You don't have to disclose your address, though.
I am the plaintiff in this case. I married the defendant on June 8th, 2013 in Marshall, Calhoun County, Michigan. I filed a complaint for divorce on May 5th, 2023. I lived in Michigan for 180 days and in Calhoun County for 10 days immediately prior to filing this complaint. When I filed my complaint for divorce, all the statements were true. There has been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. I do not believe there is any possibility of reconciliation. I am not currently pregnant, the defendant, and I have 3 minor children together. I've read all of the terms of the proposed judgment of divorce, and I agree with them. I ask that the court grant an absolute judgment of divorce. Thank you, Your Honor.
Thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The file does appear to be in order. We do have front of the court approval. We have, again, completed the statutory waiting period. The defendant has appeared, stating he does not oppose or object in this matter. As a result, the court will enter the final judgment and UCSO in this matter. That will conclude your case. You are divorced. Best of luck to both of you. I hope everything works out for you. And the court will end this proceeding at this time. You're free to go.
Hello. You're still muted, sir.
There we go. Sorry about that.
Okay. Mr. Caris, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
Yes, sir.
Court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this matter?
Yes, sir.
Okay, Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Ms. Brown, you can proceed.
Thank you, Your Honor. Mr. Caris is before the court today for a bench warrant hearing on 2 dockets. Mr. Caris failed to appear on May 31st of 2023 for an adjourned show cause hearing before Your Honor. On the 2012 case, he has a monthly obligation of $267.50. His last payment was October 6th of 21, and that was $68.04 through an income withholding with unemployment. This is the 4th bench warrant. He's had 4 prior contempt findings. His total shortfall today on the 2012 case is $5,350. Total arrears through the end of January, $18,799.50. On the 2019 case, Mr. Caris has a guideline. It's arrears only, monthly obligation. Actually, his arrears are just $447.97. But what he was paying at the last time with the current support, the guideline amount would be $405.97. His last payment was September 1st of 21. That was $25. This is the 3rd warrant. He has had 0 prior contempt findings on the 19 case. Again, his arrears are $447.97 through the end of January. Friend of the court would just like the court to be aware that we have repeatedly requested medical documentation speaking to his ability to work, and Mr. Caris has failed to provide that.
Okay. Mr. Sackrider, do you contest or dispute any of the statements made by Ms. Brown?
Ms. Brown, are you aware of any large settlement payments going towards Mr. Caris's child support arrears?
No, not at all.
Okay. I have no further questions for Ms. Brown. All right, Mr. Caris, can you hear me?
Yes, sir, I can.
You heard the testimony of Ms. Brown. Was there anything that you disagreed with?
On the amount owed, because I just got something from the 37th District Court of Calhoun County Justice Center saying that on my daughter's case, me versus Janet Shepard, total due is only $700, and the total, and then case 2015 DP Green versus Caris says I only owe a total of $471 and past a total between the two is only $1,171 and past arrears owed.
All right. For the 2012 case with Janet Shepard, does it show that a large payment was made?
No, all it shows me is I got a balance due of $700 now.
Okay. And are you aware of a payment being made?
I had a lawsuit settlement come in. I was supposed to be for $75,000. I received $4,000 of my lawsuit settlement, and that's all I received out of my settlement. So I'm guessing the rest of my stuff went to child support because I just got this paper 2 days after I got the check saying that I only owed $700 left between my son and my daughter. I only owe $1,171 in past arrears.
All right.
Between the two cases.
What's the date of that correspondence from the 37th Circuit Court?
It's this paper right here. It does not have it. It does not give me a date on. Oh, 2/9/2024.
Okay. And does it say who it's from?
It says right at the top, the letter heading is the same as the top of all my other stuff I get from FC. It says 37th Judicial District Court, Calhoun County Justice Center, 61 East Michigan Ave, Battle Creek, Michigan. And then it gives 49014 and then the phone number, and that's it.
Okay. So you received a settlement from a lawsuit?
Yes.
Do you recall when you received that?
I posted my bond on, I think it was the 3rd. I got home and received my check 2 days later and then received this in the mail 2 days later after that.
Okay. All right. And it's your testimony that that settlement was garnished to pay for your child support?
That's the only thing it could have been garnished for.
Okay. All right. So you show a balance of approximately $1,000 in both cases.
$1,171 between the two child support cases.
All right. All right. On the 2019 case with Monica Green, how many children do you have with her?
I now have 2 children with her. The son that's
Okay.
in the thing, and then I have another son with her.
All right. And do you live with her?
We've been living together since before we were married. Since my son's been 9.5 months old, we've lived together.
Okay. And when did you get married to Miss Green?
I got married to her. It was March 8th, 2020.
Okay. And you're still married to her today?
Yes, I am.
And she lives with you?
Yes, she does.
And you have 2 children together now?
Yes, we do.
And they live with you also?
Yes, they do.
All right. Have you taken steps to file a motion to have this support obligation terminated?
We've tried that. We've tried to do it with Ms. Brown. We get nowhere with it. We brought in all the paperwork saying we're married and everything, how long we've been married for and everything else. All of that's been turned into the courts. I'm not even on my son's birth certificate like I'm supposed to be done as of now already. Because the courts haven't done their job yet and filed the paperwork like they were supposed to. I went to go get my son's birth certificate. I was like, I'm not on his birth certificate. Why am I not on it? They're like, well, you gotta go through FOC. You gotta sign I signed a paternity of affidavit saying that I was his father. That there was no one else could be his father. I've not even been put on his birth certificate.
Okay.
And we were told by the county clerk that is FOC's job to get the birth certificate changed. It is not my job.
All right. On the 2012 case with Janet Shepard, how many children do you have with her?
1. She's the only child. Caitlin is the only child I have with her.
All right. And where does Caitlin live?
Oklahoma. With
And
her
who does-
brother. With her
With
brother.
brothers?
Yes.
All right. So your child, Caitlin, does not live with Janet Shepard?
No, she does not. She hasn't for the past 2 years. And FOC has been notified of this.
You've told FOC of this?
I told Miss Brown it herself. I also notified Miss Brown of all the CPS cases that were being opened against my daughter's mom for fighting in front of her husband, or fighting in front of my daughter with her boyfriends. I had CPS call me multiple times on it, and I called FOC about this. Nothing was ever done. No one got back to me about nothing.
All right. Who does your child with Janet live with?
She lives with her brother Tyler Shepard,
And where do they live?
Oklahoma City, Oklahoma. He's in the He's in the military. They live on a military base.
All right. Are you currently working?
No, I'm not. I'm in the process of filing for disability.
All right. What is your disability?
Limited use of my left side. Most days I can't even hardly walk anymore because of a car accident.
When was the car accident?
It was March 12th of 2022.
All right. And is that what the settlement was from?
Yes, sir, it is. It's one of 4 that is going to happen.
All right. Ms. Brown testified that you've repeatedly failed to provide the court with medical documentation of your disability. Do you disagree with that?
Yes, my lawyers have tried to contact FOC.
Who's your lawyer?
Benjamin Jeremati.
Is that for the
It is for my
lawsuit?
lawsuit settlement. Yes.
All right.
Are you there?
Oh, we lost him. Okay, hold on. There's like a duplicate here. Fuck you. Fuck you. Fuck you. Fuck you. Okay. Can you still hear us? Okay.
Yes, I can.
Okay, continue.
Okay. All right. Mr. Caris, she testified you posted a bond. When was that?
Just before I was in front of Kirkham there. It was on I think it was like the 3rd that the bond was posted.
What case was that for?
It was I paid a $400 bond for Janet for the case of Janet Shepard versus me, the 2635 DS, and then I paid a $100 bond on the 2015 DP Green versus Caris.
All right. And are you willing to put those towards the arrears, or they already have them? Okay.
I don't know. I don't know if the courts have already applied them or not.
All right. Is there anything else that you would like to tell the court?
I mean, I'd like to get my license back since, I've paid down my child support because they took my license from me. I'm not going to be able to get to any of my appointments that I have to have for me to do my, because I know I'm going to have to see some doctors when I go through for my disability.
Okay.
And without a license, I'm not going to be able to get to my appointments.
Okay. All right. Thank you. I have no further questions.
Okay. Well, it sounds like we have some obviously issues here as to whether there was a settlement, whether there was a payment on that. What I'm going to do is I'm going to adjourn this matter to April 17, 2024 at 8 o'clock a.m. and we'll take it up. That'll give us time to look into whether there was a settlement that came in and again eliminated that particular rearage and just what it is, and allow Mr. Caris to file for his disability, and we'll see how that is at that particular time. So, Mr. Caris, you'll have to be back on the April 17, 2024 date, and if you do have that medical documentation that you've stated, provide that to Ms. Brown so we can have that in the file before that hearing. Okay.
Yes, sir.
Okay.
Your Honor, I'm sorry. On April 17th, could we set the time at 8:45 a.m.?
Yeah, 8:45 a.m. is fine.
Yeah.
Mr. Caris, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, I do.
Or as appointed Mr. Sackrider represents you, have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this hearing?
Yes, I have.
Mr. Sackrider, are you ready to proceed?
Yes, I am, Your Honor.
On the 2019 case, the parties are married, and the total arrears owed on that case is $347.97. The 2012 case, Mr. Caris has a monthly obligation of $267.50. His last payment was October 6th of 2021. That was $68.04 through an income withholding with unemployment. He's had 4 prior contempt findings. For 2 months of compliance, Mr. Caris should have paid $535. He's paid nothing. Total arrears on the 2012 case is $18,765.50. Friend of the court would like the court to be aware that the hearing today is actually a compliance hearing. He was before your honor on February 24th. At that time, you adjourned the matters to monitor Mr. Caris's Social Security claim.
Okay, hold on, oh, there it is. I get my notes from that other hearing. Okay,
Okay, yeah.
go ahead.
Since that hearing, friend of the court has not been able to confirm that Mr. Caris has even applied for benefits. He has also failed to submit medical documentation to our office repeatedly. So here we are today. That's
Okay.
all I have.
Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Brown?
No, Your Honor.
Okay. Any questions for Ms. Brown?
No, Your Honor.
Any proofs?
Yes, I call Mr. Caris.
Okay.
All right, Mr. Caris, you heard the testimony of Ms. Brown. Is there anything that you disagree with?
I got paperwork in the mail from the court saying that I only owed a total of $770 on Caitlin. And it was like $441 at the time on my case with Elijah.
Okay. And who are those papers from?
The courts there in Battle Creek.
Okay. And what do you take those papers to mean?
That's all I owe. It says in total I owed what was the total of those two amounts, and that was it. It didn't say nothing about 18,000 or nothing else. That's all it said I owed.
Okay. Ms. Brown testified that this was adjourned for you to provide medical records. Did you hear that testimony?
Yes, I did.
Did you provide medical records to Ms. Brown?
I didn't even have a doctor at the time. I just now got insurance on the 1st of the month, so I could go and get scheduled with a doctor. They're scheduling out way out months and months now, and I've got one set up for the 1st of the month.
Okay. What is your disability or injury?
I have shoulder injury, neck injury, and back injury.
All right. Are those preventing you from working?
Half the time I can't even walk. My left leg goes numb. It gives out on me. And then I'm for a day or two, I can't feel nothing below the waist.
All right. When was the last time you were employed?
Right before the car accident.
When was that?
2002. I mean, no, 2022. Sorry. Sorry.
All right. You filed for disability?
Yes, I have.
When?
Like 3 weeks ago, I think it is.
All right. Do you have a lawyer helping you with that?
Not at the time. I don't.
All right. How have you been supporting yourself?
I haven't been able to do anything. I'm stuck. No way to get around, no way to do nothing right now.
Do you have an income?
No, I do not.
Have you been applying for jobs?
If I can't walk, how am I supposed to do a job?
All right. Where have you been living?
With a friend of mine.
Okay. Are you a veteran?
Yes.
Have you applied for any VA benefits?
Yes, I have. And they, for some reason up here in Michigan, they cannot find my file. But if I go down to Virginia and get my file, they find it.
All right. So you are eligible for benefits?
Last I knew I was.
All right. Did you post a bond at this matter?
Yes, I posted a $400 bond for the Janet Shepard case. And then I posted a $100 bond for the Monica Caris case.
All right. It was your testimony that your daughter Caitlin does not live in the state of Michigan. Is that correct?
Yes, she doesn't even live in the state of Michigan.
So she does not. Does she stay with Janet Shepard?
No, she does not. She lives with her brother on a military base down there.
Okay. Are you willing to file a motion to have that support modified?
Yes.
All right. Anything else you would like to tell the court?
I'm trying to do everything you guys want me to. I'm sorry it takes so long for the medical out for them to get up here where I'm at. But I am trying to follow with what you guys want me to do to show you the proofs and everything.
All right, thank you. No further questions.
Mr. Caris, from the last hearing, I have my notes, and when you were asked at that time as to why you were disabled, you said you had an injury to your left thigh. You did not mention your shoulder, neck, or back at that time. Why is that?
It's my whole lower section, my hip, all across my lower back. It's the whole lower section, my hips and everything.
Did you simply forget to mention your shoulder, neck, and back the last time?
Yeah, actually, I did, Your Honor.
How have you supported yourself if you haven't worked since 2022?
I had a lawsuit. That's where I thought I thought all my child support. I got the paperwork from you guys saying that I only owed so much because it got taken care of from my lawsuit. That's what I thought. That's what I was told. Is anything from child support would come out before I got my money.
Okay, it might tell you that it would come out, but it didn't say that they collected anything at this point. Has your lawsuit been resolved?
Not if you guys haven't got your portion, because I didn't even receive nowhere near the amount they said I was going to. And I tried to call this law firm, and now they won't answer the phone at all.
Ms. Brown, you didn't mention any lump sum from any action. I would assume you haven't gotten anything?
Nothing, Your Honor. We haven't even sent out a lien to an attorney. I've never been provided any of that information about a lawsuit. We haven't received a lump sum payment. There hasn't been a lien established. It's been we're approaching 3 years that I've been requesting medical documentation from Mr. Caris, and he's never submitted it. So there's a pattern of him stating that he has injuries, but there's never been any verification of any of that to our office.
Mr. Caris, in the 3 years, why haven't you provided that medical?
I did send in some documents of some work of my doctor signing me off work saying I was not able to work. And the court, and then I got told that those weren't good enough. And they were directly from my doctor.
Okay. Anything else that you'd like me to be aware of, sir?
Not that I know of. Not that I can think of.
What's your education background, sir?
I have my GED and then military training.
Okay.
I also have vocational school, an electrician's vocational school.
Your Honor, may I?
Yeah.
Yeah, I overlooked this initially. So there is a cost recovery request from the sheriff in the amount of $74.38 associated with the bench warrant back in February when Mr. Caris was before the court. So
Okay.
we'd like to address that today.
Okay. Anything else, Mr. Sackrider?
No, nothing further.
Okay. Court will make the following finding in this case. Mr. Caris has appeared. He did appear previously before the court back in February. The court adjourned the matter to today's date to give him an opportunity to do a number of things that he could do. He stated that he was pursuing some disability. We haven't received any information about that. We haven't received any information concerning his medical situation. He claims he was injured back in an accident back in March of 2022, so it's now 2 years post. We haven't received any information about that. He said he submitted some medical information, but it was not sufficient in this particular case. That's not unusual where doctors will submit something, but it doesn't delineate what their disability is or the time off or what their limitations are. And he was informed of that, but he hasn't followed up and gotten anything. In fact, he said up until just recently, he didn't even have a doctor and he didn't have insurance that he did. Now he set up something for the first of the month. He also noted that back in February, when the court asked him as to his disability, it was with his left thigh. Now he's stating that his injuries are to his shoulder, neck, and back. And that he does have GED. He has also electrician vocational training. in this matter, but he simply hasn't worked since 2022. And he's well aware of the support obligation in this matter. Court will find that he's not made a good faith attempt at compliance. He's failed or refused to comply, and therefore he's in contempt of court. Anything before sentencing, Mr. Sackrider?
Your Honor, you heard testimony from my client. He is a veteran. He's been struggling essentially with homelessness. He's staying at a friend's. My client, I do believe, is eligible for benefits. However, he doesn't have the means or the wherewithal to obtain them. We would ask that if the court does impose a jail sentence, the court say purge him out in the amount of $100, Your Honor. Thank you.
Okay, thank you. Court does note that he had 4 prior contempts findings on the one case, and the other he had 0 prior contempt findings. The court is first going to order that you reimburse the sheriff transportation costs of $74.38. The court would forfeit the bonds previously posted in this matter. The court is going to sentence Mr. Caris to 45 days in jail with credit for no days served. The court would order that he report to the sheriff no later than 4:00 p.m. on April 26, 2024. Sir, if you don't report at that time, you could be sentenced to a greater period of time and serve, in fact, more than the 45 days. The court would allow him to purge himself of contempt by paying the sum of $500. So if you're able to pay the $500 before the April 26th date, then you would not have to serve the time in jail. Do you have any questions, sir?
No.
Okay.
Your Honor, I do have a question. So the $500 purge is on the 2012 case, on the case where he is married to the respondent and the arrears are just over $300.
I'm putting zero purge on that.
Okay, just to be sure. Thank you.
Yep. Okay. Thank you. You're free to go. Have a good day.
Here is Mr. Smith. We're ready for your hearing.
Yes, I can hear
That's all
you.
you're hearing,
Okay.
right, Sonny? Please, telephone only.
Okay. And Smith is the name?
Yes, Cody Smith.
Mr. Smith, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, sir.
Court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this hearing?
Yes, I have.
And Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Respondent Cody Smith is before Your Honor for a bench warrant hearing because he failed to appear for a show cause hearing on June 17th, 2022 before referee Bradfield. Mr. Smith is currently ordered to pay $342 a month for current support, $171 towards arrears, $3.50 for service and processing fees, for a total monthly obligation of $516.50. Last payment received on this docket was on September 18th, 2023, in the amount of $144.02, and that came through income withholding. Mr. Smith did post a bond in the amount of $1,182 on this docket on January 28th, 2024. This is his first show cause, first bench warrant, and he's had no previous findings of contempt. I measured his compliance over the last 12 months. Mr. Smith should have paid $6,198. He's paid nothing, so that leaves him a shortfall of $6,198. Total arrears on this docket through January 31st, 2024 are $11,614.44. Mr. Smith was incarcerated from January 27th until January 28th, so that would give him credit for 1 day in jail.
Okay. Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Mouton?
No, Your Honor.
Do you have any questions for Ms. Mouton?
Yes.
Go ahead.
Ms. Mouton, does Mr. Smith qualify for the LEAP program?
He does not. He lives outside of our service area.
Okay. says here that the last time the child support order was modified was in 2020. Is that correct?
That's correct.
And do you have the address that the notice was sent to for the June, I believe you said 27th of 2022 hearing that he failed to appear at?
That I never got any information for.
Just one second. It's a confidential address, so give me one second. It appears to be the same address that we have on file.
Do you know that address, the street at least?
If it's a confidential address, I can't say that on the record.
Okay. His address is confidential or hers is?
His is.
All right. Has the bond that was posted been put towards his arrears?
It has not.
All right. All right. Thank you. I have no further questions.
Okay. Any proofs, Mr. Sackrider?
I call Mr. Smith.
Okay, go ahead.
All right, Mr. Smith, can you hear me?
Yes.
You heard the testimony of Ms. Mouton. Was there anything that you disagreed with?
I didn't receive any paperwork about a court date, or I would have been there. For one.
All right.
For two, why wasn't my bond posted? Why wasn't that put towards my rearages?
All right. Were you aware of your child support obligation?
Yeah, I've known that I've had to pay $526 since 2020.
All right. It says here your last payment was in September 18th of 2023 through income withholding. Were you employed in September of last year?
Yeah, I'm still employed through said company. I'm laid off. They don't have work close enough for me.
All right.
The company's out of Grand Rapids, but they do work out of Holland, South Haven, all around.
Where are you employed at?
Great Lakes Skill Trades out of Grand Rapids.
All right. What kind of work do you do?
I'm a general laborer.
Okay. And you've been laid off since last September, is that correct?
Yes.
Okay. How have you been supporting yourself since that time?
My wife has a job.
All right. So you live with your wife?
I live with my wife and our two children.
Okay. Is there any payment that you could make on this case? Or what is your plan to pay in the future?
Well, I plan on having me and the wife are going to make a payment next week.
And how much is that?
Anywhere from 100 to 150. I
All
also
right.
have to pay bills. I have a life of I have a home of my own. I don't live with my mother. I have my own responsibilities.
All right. Are you willing to put the bond that you posted of $1,182 towards the child support arrears?
Yes.
Okay. Are you going to receive a tax refund soon?
Yes, I will be filing my taxes today. I just finally got my last W-2 in the mail last week. I just haven't gotten around to filing. I've been stressed out about court and everything else. I will get it filed today, and that back money, child support automatically takes it. They'll automatically have it. And whatever I get from federal or state, whatever the child support don't touch, I'll bring down and I'll pay you that too. I'm tired of dealing with this. I'm tired of being in the court system when I take care of my son when I have him. I'd like more time.
All right. How many children do you have with Miss Hunt?
I have one child. I have one biological kid.
All right. How often do you see that child?
I see him every other weekend right now, as said with mother.
Okay. Are you willing to apply to the court to modify your support obligation or change your parenting time?
Oh, as soon as I go and make a payment next week, I'll be filling out the paperwork to revise my parenting time. I want more time.
Okay. All right. Since September of last year, have you been looking for work?
Yes, I have. I have put in 6 applications a day, roughly every day since being laid off through Indeed.
All right. And what responses are you getting, if any?
That's just it. If any, none. I felt like I got into an argument with Walmart the other day begging for a job. And I mean, it's to that point where, you know, somebody with a 9th grade education shouldn't feel like they are begging for work.
All right. Your highest level education completed is 9th grade.
I have supported my wife through her schooling this year, and next year I will be applying to do the same. She's a credit and a half away from having her high school diploma this year, and I will be working on mine next.
Okay. All right. Do you have any current expenses?
I have rent that is almost $800 a month. Electric, which runs because I heat my house with electric because it's cheaper than propane. About $200 a month.
Okay. Anything else?
No, besides child support and keeping gas in the vehicle.
All right. All right. What's your plan to pay this obligation in the future?
Well, for now, it's to make payments as I can until I get employment and can start making payments again. I am in the process of working for employment. It's not like I'm just sitting here on my butt. I'm trying.
Okay. Anything else you would like to tell the court?
No.
All right. Thank you. I have no further questions.
Mr. Smith, you stated that you, since September to currently, you put in approximately 6 applications a day looking for employment. Why have you not been able to acquire employment?
One vehicle, prices of gas. I have 2 other kids to make sure that they get on and off the bus.
Okay.
I've actually been doing
That doesn't tell me why. That doesn't tell me why you haven't gotten employment. Those are other responsibilities.
People won't hire me.
What?
I can't tell you why people won't hire me.
I can afford childcare.
Well, have they told you a reason? I mean, the labor market is really tight, so it would seem like you'd be able to acquire employment.
Employment doesn't have to give you a reason on why they won't hire you.
I'm not saying they have to. I asked you if they did.
Well, they haven't.
Okay. Did you tell me with Great Lakes, so why you've been laid off? Why has it been so long that you've been laid off?
Because honestly, it's been easier employment-wise for the wife and kid-wise for our kids for me to be at home to get them on and off of a bus. I don't have a driver's license. So I can't drive myself anywhere legally.
Okay, that doesn't tell me why you've been laid off for that particular time. So have you taken a voluntary layoff? Is that it?
Tell them that because your wife couldn't afford the gas money since I'm not going to
Hold on. I don't know who's talking. This isn't Mr. Smith. This isn't Mr. Smith, so don't talk.
I'm not going to be told what to do in my fucking house. Yeah, fucking yeah.
Ma'am, if you want to be held in contempt of court and go to jail, keep it up.
So she's no longer here.
Okay. Mr. Smith, why you say it's easier? Have you taken a voluntary layoff? Is that it?
Yes, so I can take care of the other 2 children in my home. Because my wife's job was closer and easier on the gas.
Okay.
I was working all the way out in Holland at the new fucking Energizer factory. And I'm sorry for my language, but like I said before, I'm a laborer. I don't have the best vocabulary.
Well, don't swear. You can do that. You can respond without swearing, sir.
I'm a little frustrated at this point because I'm being made to be like I'm a bad person when all I failed to do is pay some fucking fines.
Okay, sir, if you keep swearing, I can hold you in contempt and you can go to jail. Do you want to do that?
No.
Okay.
But of course, there's no understanding for a father's frustration. It's all about the mother of this court system.
Well, say what you will. We're dealing with you right now. We're not dealing with the mother in this case.
Because there is such thing called the freedom of speech, and I am defending myself.
All I'm asking you to do is answer questions, sir, not defend yourself. To answer the questions I ask.
I will to my best ability.
Anything else that you would like the court to be aware of?
Nope.
Your Honor,
Yes.
friend of the court did make a mistake. We did receive payments from August 14th and through September 18th. So we received payments in the amount of $646.85. So that would leave Mr. Smith with a shortfall of $5,551.15.
Okay. Okay, thank you
And
for
what
that
about-
clarification.
What about the 1,186 to bond myself out? What does that go towards?
Sir, that doesn't get taken care of until today's hearing, so you wouldn't have gotten credit until such time as the court forfeits the bond. So it's nothing that the front of the court has done. They can't do it till we have the hearing. Anything else, Mr. Sackrider?
No further proofs, Your Honor.
Okay. Well, in this particular matter, the testimony has shown that first, the court will note that there is a bond posted in this matter. The court will forfeit that bond. In this matter, apply that towards the arrearage in this particular case, that Mr. Smith does not have a prior finding of contempt in this particular case, that he does owe approximately $11,600 in arrears. With the reason amount of the correction, it would be just under $11,000. That court would note that he had received 1 day credit for time in jail in this particular case. That court notes in the testimony in this matter that Mr. Smith has been laid off from Great Lakes Steel Trades, that he had worked through approximately September of 2023, that he has taken a voluntary layoff, as he states it is easier to, again, to handle and to handle his current children, his household in this particular case. He stated that since that time, he's put in 6 applications a day. Was looking for work. He does have a 9th grade education. That again, acquiring employment, he said, has been hindered somewhat by the fact that he has 1 vehicle and he has some gas issues and for as far as expenses in this matter. However, it does appear, because he's taken the voluntary layoff, that he has in fact failed to comply with the order in this case. He said he's known about this since back in 2020, that he's failed or refused to comply in this matter. The court will therefore find him to be in contempt of court. Anything before sentencing, Mr. Sackrider?
Yes, Your Honor. As Ms. Mouton testified, this is a first show cause hearing for Mr. Smith. He testified that he's willing to put that bond over $1,000 towards the arrears, which the court has done. He testified that he's filling out 6 applications a day. So in this matter, we would ask that he be sentenced to time served, the 1 day served, and that he be allowed to continue to look for work and make payments on this child support obligation. Thank you.
Okay, thank you. Well, what the court's going to do, Mr. Smith, the court could sentence you up to 45 days in jail. I'm not going to do that, but I do feel that some amount of jail time is warranted. The court will sentence you to 14 days in jail with credit for 1 day served. The court would allow you to purge yourself of contempt by paying the sum of $250 in this matter. I'm going to require that that purge amount be paid, or you report to jail no later than 4 o'clock on March 1, 2024. And that will be the order of the court. So you'll report to the Calhoun County Sheriff on March 1, or pay the purge amount in this particular case. So that will be the order of the court, and you're free to go. Have a good day.
Hey, so if I come down and what you're telling me is if I come down and pay the $250 today, it takes care of this, right?
Yeah, if you pay it by the March 1st date, so you pay it today or any time in between there, then you wouldn't serve the jail time. That's correct.
Well, you will have your money today, sir. Thank you.
Okay, thank you then. Have a good day, sir.
Thank you, Your Honor. That's all I have.
Okay, thank you.
You're welcome.
All right. Now, can you hear us, sir?
Yes, I can.
Okay. Mr. Parker, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand that?
Yes, sir.
Court will advise you that court has appointed Attorney Sackrider to represent you in this matter. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this hearing?
Yes, I have.
Okay. And Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Okay. Thank you, Trulio.
Thank you, Your Honor. This is the case of Cheyenne McHugh versus John Parker. He's before the court today by way of a bench warrant after failing to appear at a compliance hearing on April 21st of 2023. He is ordered to pay $502 a month current child support, $87 a month for the confinement expenses. With the arrearages being paid at guideline, the total monthly obligation is $843.50. His last payment paid was $160.11. It was the only payment paid on the history of this case, and that was paid in February of 2023. He did post a $500 bond that I'm asking be forfeited and applied to the arrearage. He's had one show cause in this matter. It resulted in this bench warrant. There have been no findings of contempt. In the last year, he should have paid a total of $10,122. He's paid $160.11. The total shortfall in the last year only is $9,961.89, and he owes an arrearage through the month of January of $12,745.39. He did book into the county jail on February 11th. He was released on February 17th, so he has credit for 6 days served, and he's had no prior jail sentence.
Okay. Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Petrulio?
No, Your Honor.
Do you have any questions for Ms. Petrulio?
Yes.
Go ahead.
Does he qualify for the LEAP program?
As far as I know, he would.
All right. Have you talked to him about that?
Well, when he was in jail and I met with him, thinking that he wasn't going to be able to post his bond, we did talk about that. And I told him to get in touch with me after the hearing, depending on what happens, to see if we can do a referral.
All right. Says that you received a payment in February of 23 of $160. Was that through income withholding?
Yes, it was one payment through income withholding. And as I indicated, that's the only payment we've received since this case started back in March of 2022.
All right. Was he employed then?
I guess. I'm not real familiar with Mr. Parker. I'm just handling this as a backup case. So I don't know the history real well, aside from the connection I'm looking at.
All right. I have no further questions.
Okay. Any proofs, Mr. Sackrider?
I call Mr. Parker.
Okay, go ahead.
All right, Mr. Parker, you heard the testimony of Ms. Petrulio. Was there anything that you disagreed with?
Yeah, because she never told me about no leak program, so that's a lie right there. We never even talked about that. When she called me, when she called me down to go to court, I was over. We never met up or nothing. This is my first time seeing her face. She told me over the phone that I owed how much money I owed, and that when I got out, I needed to get a job. That's what she told me. She never told me nothing else that she's telling you guys.
Okay. This is a case with a Cheyenne McHugh. How many children do you have with Miss McHugh?
I got one children with McHugh, and I take her every Thursday into Sunday, and then that's when McHugh comes and pick her up on Sunday, and then I get her and keeps her until Thursday, and I stay with my grandma and Cheyenne McHugh off and on because I don't have nowhere to go. I don't have income, and that's what it is.
All right. It says here that this is a uniform support order that was entered in 2018. Were you aware of a child support obligation?
I didn't. I'm not in 2018. No.
All right. When did you become aware of it?
I didn't even know that I had anything about no court in 2018 because I never even had kids until I turned 26 years old. So I don't know I don't know about that.
All right. When did you ever become aware of a child support order between you and Cheyenne McHugh?
After I took my DNA test on my kid.
When was that?
That was last year, 2023.
Okay. She testified that the current monthly support obligation is $502. In addition, there's $251 in arrears, and then some other fines and costs totaling $843.50. Were you aware of that?
No, I didn't. I wasn't aware of how much I got, like how much I owed or none of that. And my address been the same. It ain't changed. It's always been the same.
All right. When she testified that you missed a show cause hearing on April 21st of 2023. Were you aware of that hearing?
I never got mail about that. Not one time. So I don't know if she got a different address for me or what, but I never got mail on that. I always got my mail from the same address since I've been in the court system.
All right. When was the last time you were employed?
Last year, 2023.
And where were you employed?
Event or I was down there on AC Foundries.
And what kind of work was that?
That's pouring metal.
Pouring metal. All right.
Yep.
When did you stop that work?
I stopped that work when me and Cheyenne broke up of 2023, and I moved to Kalamazoo.
All right. Do you remember approximately when that was?
No, I don't.
All right. And so what happened? You stopped working there?
I stopped working there because I moved to Kalamazoo, and when I moved to Kalamazoo, I didn't have a car to get back and forth to work, so I stopped working there, and I ain't had a job since.
All right. Have you been applying for jobs?
Yep. I've been going on Indeed. I've been filling out applications. I gotta go down to Baymont, down there by Battle Creek Central today, because that's where Cheyenne McHugh's mom works, and that's where she told me to get a job at, is so I can fill out an application down there. So I'm going down there today, and then I got another one that I gotta go to, which is Perry Farms out on Dickman Road. I gotta fill out an application out there too.
All right. So let's say during this year, 2024, approximately how many applications would you say you filled out per day?
I say I done filled out a good 20 applications, and a lot of them denied me because I got embezzlement, which is fraud. And a lot of them told me that they can't hire me because they don't know what I would do when I went in for my interview.
So you have a felony conviction from your past for embezzlement?
Yep, and they put that on my record, and ever since then it's really hard to get a job with that on my record because they don't know if they don't know what I'm gonna do.
All right. How have you been supporting yourself recently?
I've been going to the Biomat, which is donation on 20th Street. And I use that to feed myself, but some of it I use it to get my daughter's diapers and wipes. That way I got them when I have my daughter.
Where do you live?
Sometimes I live with my grandma, and sometimes I stay at my grandma's house for like a week, and then the next week I leave my grandma's house and I'll go to Cheyenne McHugh's house.
All right. And how many children do you have with Cheyenne McHugh?
I got one.
And do you receive parenting time with that child?
I watch it when I'm at my grandma's. I have her from Thursday to Sunday, and then Cheyenne picks her up on Sunday. And then when I'm at Cheyenne's house, because like I said, I stay at my grandma's house from time to time, but then I go off and on between my grandma's house and Cheyenne's house.
All right. Are you willing to file a motion with the court to modify your support obligation or your parenting time schedule?
What do you mean?
Your current obligation is $843.50. Are you willing to file a motion with the court to have that lowered?
Yes. Yes, sir.
Have you ever been able to afford $800 or $500 per month?
I don't even know where they get that at, because I never even made nowhere near much money as they think I'd have made. I never made none of that.
What was your hourly wage when
Like,
last time you were employed?
The most my check was at AC Foundries. The most my check was like five. I think it was like 560, 570, something like that. And they took that. They took 100 and something out. So before I even got it.
All right. All right. What's your highest level of education achieved?
I dropped out in like the 8th grade.
All right. Are you willing to obtain or attempt to get your GED?
I'm in special ed classes. I would have to do a lot, and I don't know how to read like that. I don't know how to spell like that.
All right. Do you have the ability to read or write?
No, it's got to be small words. It can't be big words at all. I know how to spell, but I don't know how to spell a lot of words, so it would be hard.
All right. Do you have any diagnosis?
Yes, I got diagnosed with bipolar, schizophrenic, depression, PTSD.
All right. Are you receiving treatment for those diagnoses?
I'm supposed to be taking medicine, but when I take it, it makes me feel weird. It makes me like jittery, and yeah.
All right. All right. Anything else that you would like to tell the court?
No, I just need I take care of my kid. I take care of my kid like I'm supposed to. I do what I got to do for my kid. So I can do the best I can. The best I could do is keep looking for jobs and keep trying to do what I got to do.
All right. Would you participate in the LEAP program if it was offered to you?
If it was offered, and I actually know, like, yeah, I would. I would like it.
You would like help finding work?
Yeah, I would like help finding work. If I get a job, I can work. I know I can, like, I know that, but it's just hard for me to get a job by myself.
All right.
Because yes, I don't. It's hard for me to read some of the stuff. It's hard for me to spell. Like when I fill out an application, I have to look at my ID to spell electric. I have to look at my ID for a lot of things. Like it's hard for me to spell and write.
All right. All right. Thank you. I have no further questions.
Okay. Mr. Parker, you said that you left the job at the AC Foundry as you moved to Kalamazoo, and if you had a chance to continue to work there, why did you move?
Because I didn't have nowhere at that time. My grandma did not live down here. She moved to Detroit. So because of her problems with her son up there, so she had to move up there. So I didn't have nowhere to go because me and Cheyenne McHugh was fighting, and that's where I was living. But we broke up, and so I had to move somewhere to where I had somewhere to stay.
Okay. Aside from selling plasma, as you stated, have you had any other income since you left the foundry back in would have been approximately February of 2023?
No, I haven't. Like that's been my income every since I quit that job. Like that's really all I have been doing. Like they pay me $45, and that's I paid $13 and something and some change for my daughter's diapers and wipes. That way when I get her, I got diapers and wipes for her, and then sometimes I still you know, she eats our, she's not no baby no more. So now she's eating food. So I got to pay for her food too when I got her.
Okay. And that's expensive to raise a child, isn't it?
Yeah, it is, especially with the way I'm, you know, me not having, and then sometimes I gotta find places because my grandma really, she's older now, so my grandma, that's a lot for my grandma sometimes. So then I gotta find places to go with her sometimes too.
Yeah. You understand that again, it's expensive for you to raise a child. It's expensive for the mother as well.
Yes, it is.
Anything else you'd like me to be aware of, sir?
No, sir.
Okay, thank you. Well, in this particular matter, the court will note the respondent has posted a bond in this matter. The court will forfeit the bond previously posted this matter. The court would order that Mr. Parker would participate and successfully complete the LEAP program. In this case, Mr. Parker has testified that, again, he had a job at the AC Foundry. He left that job voluntarily as he did not have housing and moved to Kalamazoo, and that he didn't have a vehicle, therefore he couldn't continue the employment. That he states that since he left that employment, he stated he'd filled out approximately 20 applications. That again, looking at the time frame, it looks like that's over a period of a year. Sure, someone can fill out 20 applications in probably one day. It doesn't take them a whole year to do that. The court does not, again, find that that is sufficient or substantial attempt at acquiring employment in this particular case. He states that he's been hindered in somewhat because he had an embezzlement or a fraud conviction, and therefore they've not, individuals have not been willing to hire him, that he has a limited education background, even having been dropped out in either the 8th or 9th grade, that he has also some mental conditions in this matter that he would take medication for. He doesn't take the medication, as he states it makes him feel weird. He says that he can work and is able to work, but has not done so in now over a year. Court will find that he has not exercised a good faith attempt at compliance. He's failed or refused to comply, and he is in contempt of court. Anything before sentencing, Mr. Sackright?
Yes, thank you. Your Honor, Mr. Parker testified that current child support obligation essentially has never been able to afford. We would ask the court to order a review of his child support. He's testified that he's unable to read and write essentially any large words. He does need help finding employment. The felony in his record is hindering from finding employment. He testified that he's willing to work, but that he's been having trouble lately. He also testified that the parenting time schedule as it currently is not being reflected in the support order as well. This is his first show cause, and we would ask the court to allow him to participate in the LEAP program and gain employment and begin paying on this obligation. Thank you.
Thank you. Well, Mr. Parker, the court could sentence you up to 45 days in jail. I'm not going to do that substantial of a sentence. What the court is going to do, the court is going to sentence you to 14 days in jail with credit for 6 days served. The court would order that you would report to the Calhoun County Sheriff no later than 4:00 p.m. on March 1, 2024. The court would allow you to purge yourself of contempt by paying the sum of $300. So if you should pay the $300 prior to the March 1st date, then you would not have to serve the jail time. Do you have any questions, sir?
No, sir.
Okay, that will be the order of the court, and you're free to go. Have a good day.
You too.
Thank you, Your Honor.
Havard.
Mr. Havard, in this matter, you're before the court charged with a civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
You're still muted, sir. Unmute your device, please.
We need to have you take yourself
Yeah.
off mute.
Yes,
Okay.
I understand.
Okay. Court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this hearing?
Yes.
And Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Okay. Ms. Petrulio, you can proceed.
Thank you, Your Honor. It is the case of Corinne Hale versus Javon Havard. He is before the court by way of an adjourned hearing. He's ordered to pay $143 a month, current child support, $10 for confinement expenses, and $50 a month for the arrearage repayment, for a total of $206.50 each month. His last payment paid, which I don't consider a payment, it was actually to address the bench warrant, was $50 on December 4th. He's had 4 prior show causes, 3 bench warrants, no contempt findings. I calculated what he should have paid for January and February, and that's $413. He's paid nothing. The arrearage is $980 through January 31st. But I want to give a little history here so the court can kind of get the big picture here. This whole thing started in November of 2022. On that date, we adjourned the hearing to allow him to be represented by court counsel to December 7th. On December 7th, he appeared and said he didn't want the attorney, but had a hearing before Your Honor. He was ordered to pay $50 by November 1st of 2023, and that he was required to file a motion to modify his support obligation. The matter was adjourned to January 18th of 23. On January 18th, he had paid the $50, but the motion he filed was incorrectly. I agreed to adjourn the hearing, send him a new pro per motion to file correctly, and adjourn the matter to April 26th. On April 26th, he indicated that he forgot about the evidentiary hearing to modify support that was scheduled, so it got dismissed. He wanted a hearing because he said he did everything that he was told to do. I said, except appear at the evidentiary hearing. So we had a hearing, and you agreed to adjourn and require him to file a new motion to modify support due to his failure to appear at the evidentiary hearing. And you adjourned it to June 21st. On June 21st, the hearing was adjourned to allow him to be represented by court counsel. That was adjourned to July 19th. And on that date, he had paid a lump sum payment of $800. So I didn't feel it was necessary to have a hearing because it almost eliminated his arrearage at that point. So I agreed to adjourn the hearing to November and require that he begin paying it in August. On November 1st, he said he wasn't working and he would pay the money when he got the money. So it's adjourned to allow him to have court counsel again on November 15th, and he failed to appear then. On December 20th, he had paid the $50 to resolve that bench warrant. And it was an agreement was made because he told me back in December that he had 2 weeks left of his CDL training and was hopeful about finding employment. So I agreed again to adjourn it, requiring that he pay January and February and keep in touch with me regarding his CDL. He calls in today for his hearing. I ask him what the status is of his CDL. He tells me he paid his child support in full. I said, oh, did you make a payment? No, I filed my taxes and they took my money. I said, taxes are just another remedy to eliminate child support arrearage, but what's the status of a CDL? I told you I paid my child support. So here's the picture. December 20th of 22, he paid $50. February 22nd and 23 and February 23rd of 2023, he paid $284.82, and he paid $800 on July 11th. That's the history since we started back in November of 2022. So I have no information on his CDL, what his status is. All he said is his taxes were taken. And again, these payments are required to be paid monthly. It's been made very clear. He was told to file that motion. That was 15 months ago. He has not filed a motion to modify support. So clearly, I think he's in contempt for not paying his support as ordered.
Okay. Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Petrulio?
No, Your Honor.
Do you have any questions for Ms. Petrulio?
No, Your Honor.
Okay. Any proofs?
Yes, I'd call Mr. Havard.
Okay. Go ahead.
All right. Can you hear me okay?
Yes.
All right. You heard the testimony of Ms. Petrulio. Was there anything that you disagreed with?
No, actually, to be honest, I'm surprised she got everything spot on. To be honest, yeah, I agree with her.
All right. She testified that total arrears are $980, and that you told her your income tax return was garnished. Is that correct?
Correct.
How much was your income tax return garnished? Do you know?
I had a total amount of like 1580 or something like that, and I received like $200 in my bank account yesterday. So the rest of whatever I owe went to child support.
Okay. Do you currently live in Calhoun County?
No,
Where do you live?
I stay in Warren, Michigan.
All right. She testified that you had attempted a few times to file a motion to modify the
Yes.
support obligation. Is that correct?
Yes, and I stopped trying. I really like gave up hope because I kept trying to I even found a ride to drive all the way down to Calhoun County. That's like 2 hours and like 40 minutes from where I stay, just to file that motion. And then they told me that I had to go to a post office and mail the motion to Corinne Hale. Well, I mean, I could have just pulled up on her and gave it to her, but I did what they said and I mailed the motion out. And then like she said, they said it was the wrong motion. Then they sent the motion. It's just, I gave up. I'm gonna just be completely honest. I gave up because I'm like, I just keep getting a runaround on trying to get the child support lower. It's just, I'm like, I gave up, to be honest.
All right. She testified that you were working towards your CDL license. Is that correct?
Correct.
What is the status of that?
Like I told her, and like I told you earlier, my grandmother passed December 1st. She was watching my 5-year-old autistic child while I went to school. With her passing, we couldn't even give her a proper burial, and we had to do a funeral and cremate her. My child goes to school from 8:30 to 3:30. The school was from 7:30 to 3:30. It's no way possible I could do that without the help of somebody babysitting my child. So I had to stop going to school because I got to take care of my child.
All right. How many children do you have with Miss Corinne Hale?
One.
All right. And how often do you see that child?
A lot. I just had him. They was off school all week. I had him for like 4 days. He just went back like, what's today? Tuesday. He just went back Sunday.
All right. And you purchase things for him when he eats with you?
Every time. He has a lot of allergies, like real bad allergies. So to be honest, all he really eats is fast food, McDonald's and all. I bought him some shoes while he was down here, and I bought my other son some shoes yesterday when I got the $200 from my income tax. I always buy him stuff. I can show you a history report. He has his own cell phone that I purchased him, and all he does is, Dad, cash app me 20. Dad, he has his own cash app. So, Dad, cash app 20. So if I got the money, I send it no problem without even thinking about, oh, I got to pay child support and all that. Like the only reason why I paid that $800 that one time in July 11th, because his birthday is in July. And I'm like, well, I want you to have a good birthday, but I have to pay the child support, even though the mother was like, well, just give me the money. I'm like, if I just give you the money, they going to consider that as a gift. So I have to put it on the child support. And when you get it, you'll get it. And when she got it, it was like after his birthday. That's like when I told Heather today, like it's paid off, and it might not show now, but even if I pay cash or however it comes, it's going to take like a week or two to process in the system.
All right. So you have another child that lives with you?
Yes. I only have 2 kids. Yes. My child. Yep. Havard. That's my son, my other son.
All right. And you said that he was autistic? Yes.
I get a SSI. Well, he gets a SSI check, and I have his mother on child support. She pays like $430 or $450 a month, and I have and I get food stamps. It goes up and down, but for some reason since January they've been giving me like $500 a month in food stamps for him. It's me and him on the food stamp.
All right. Is there anyone else that lives with you?
Like I said, I live with someone, so I live with them. It's not living with me. My
All right, who do you live
girlfriend.
with?
My girlfriend.
And is that who you have the child with?
No. Like I said, my youngest son, I have her mother on child support, and she's someone totally different.
All right. So you care for your child with autism full time. Is that correct?
Full time.
And he receives Social Security disability income.
Yes.
And you receive child support from that child's mother.
Correct. Correct.
And you receive food stamps as well.
Correct.
All right. All right. And so you were working towards your CDL, but your grandma passed, who was watching your son.
Yes. While I was at school, she was watching him for me. Correct.
All right. What is your plan to pay the child support obligation with Miss Hale on this case in the future?
Like I said, that's why I was trying to go through the motions to get it lowered so I could come to something that's like affordable for me to be able to pay just for situations like this. You know what I'm saying? So I won't have to be in a bind and I won't have to be in arrears. I mean, yeah, like I said, they took my taxes and it's paid off now. I just talked to Corinne Hill today and she showed me her tax income check and she like, I know that the child support took your tax money, but when I get my taxes with this, she get hers on the 27th. She said she was going to give me some money. So, I mean, we have a good relationship and that's why I was trying to get it lower so I could just, if just in case something like this happened, I can go and pay like a couple dollars and this, that, and the third. But it was $150, and then next, I just heard from you saying that earlier. You said it went up to like 206, and I'm like, how is it going up if I'm putting in motions for it to go down? Like it's kind of. I mean, I'm like, just work with me a little bit. You know what I'm saying? I'm trying, but it's like it's hard.
All right, and it's your testimony today that after your tax refund garnishment, that your obligations in this case are all paid up to date. Is that correct?
Correct. Correct.
Anything else you would like to tell the court?
No, sir.
All right, nothing further, Your Honor.
Okay. Ms. Petrulio, what's the time frame when they do an intercept like that before it shows up?
It's really hard to tell, Your Honor. I mean, I can't really say. I was at least a couple of months, but I can't say for sure. And then it depends I don't think he's married, so it probably wouldn't go on a 6-month hold, but that's a possibility as well.
Okay. Well, what I'm going to do, Mr. Havard, I'm going to take you by your word that, again, that they did intercept your tax refund. What I'm going to do is I'm going to adjourn this matter to April 17, 2024 at 8:00 a.m. And we'll check on the status of that to see if, in fact, they have intercepted that. And then that'll tell us, again, a little bit more as to whether you paid up and you're paid the arrearage or not. You have to understand between now and then, you're going to have to continue to pay on this particular case, or you're going to need to file a motion to modify your support obligation. Understand, you filed the motion previously. They said it was incorrectly filed. You didn't show up for another hearing. And as a result, you're going to have to take the responsibility to do this. The court's not going to do that. You have to file the motion. You have to have a hearing. You have to show up to the hearing. Most of the hearings you can show up by Zoom. So it's not a case where you have to come to Battle Creek to do it, but you're going to have to put some attempt at compliance and to take care of it. If you don't, by the April 17th date, or if you've not made any payments since that time, you should probably prepare to go to jail. I don't know what we're going to do at that time, but I'm giving you that final time what we're going to adjourn this to make sure to see if we can get it straightened out. If not at that time, be prepared. Okay.
No problem, Your Honor.
Okay.
And if last thing, Your Honor, the only reason why I missed that hearing is because I was at school. I was at school and it just totally bypassed my mind. But I understand totally what you're saying, and you will see.
Like the next hearing on April 17th, I don't care what you're doing at that time. It better not bypass your mind, because if you do, you're going to end up in jail.
No problem.
Okay.
Your Honor.
We'll see you back. And then, yes.
Just a question. So are the payments to commence this month, March?
Yes. Yeah, he's going to comply with the order to the court. So
Okay,
you
and
have to
then
pay this month, sir.
then will he have the attorney then next in April as well?
April, the reason I set up for that, Mr. Sackrider will be back. I don't want Mr. Sackrider to miss our hearing at that time. So he'll be the attorney unless something changes.
Okay, thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day.
You too.
Okay. Mr. Havard, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
Yes, Your Honor.
Court has appointed Mr. Sackreiter to represent you in this matter. Have you had sufficient time to speak to Mr. Sackreiter in preparation for this case?
Yes, Your Honor.
Mr. Sackreiter, you ready to proceed?
Yes, sir.
Okay.
Thank you, Your Honor. It is the case of Corinne Hale versus Javon Havard. He is ordered to pay a $332 a month in child support, $10 a month in confinement expenses. $50 would be the guideline payment toward arrearages for a total of $395.50. That includes the service and processing fees. His last payment that he paid on his own was $50 on December 4th, 2023. He's had 4 show causes, 3 bench warrants, no findings of contempt. In the last 3 months, he should have paid a total of $997.50. He's paid nothing. That included a payment toward the arrearage, and his balance through this month is $879. He did file a motion to change his support, as you had told him he needed to do if he couldn't pay the ordered amount. And basically, that amount went up from $153 to $332 a month. He objected to that. He filed a motion to set it aside and had a hearing on Monday with Your Honor. And he was imputed. So the information, I know this is going to be sent back to the referee for income information, but he was imputed roughly at $15.50 an hour, working 40 hours a week. And that's how they came up with the $332.
Okay.
And nonetheless, he hasn't paid anything on his own since December 4th, when he paid $50, which was even well short of his obligation at that time of $153.
Okay.
And just for the record, Your Honor, we can't stop charges right now because Corinne Hale remains on Medicaid and food stamps. I don't think food stamps would affect it, but she is on Medicaid, and until she goes off, there's nothing we can do about the current support.
Okay. Mr. Sackreiter, do you dispute or contest any of the statements made by Ms. Petrulio? Do you have
No, Your
any questions for Ms. Petrulio?
Yes. Was a tax garnishment taken for child support payments?
I don't believe that can be disclosed on the record.
Was he given credit for any of the
It looks
payment?
like there was a substantial payment that he did receive credit for.
Okay. So was that taken out of, so that's how we were left? I mean, was that calculated? So that's how we're left with the $879?
Yes, Your Honor.
Okay. Go ahead, Mr. Sackreiter.
All right. No further questions.
Okay. Any proofs, Mr. Sackreiter?
Yes, I call Mr. Havard.
Okay, go ahead.
All right, Mr. Havard, you heard the testimony of Ms. Petrulio. Is there anything that you disagreed with?
There's nothing I disagree with, but like said before, we had a hearing on Monday. I had a hearing with the judge, Kirkham, and I told him my situation, and that's why we're going back to the motion hearing, because that was wrong information of the amount she's trying to say that I made. Like I said, I have a autistic child that I'm a full-time dad for. He's in ABA therapy from 8:30 to 12:30. And then I take him to school from 12:30 to 3:30. So it only gives me time to work a part-time job. I've been looking for jobs. I filled out for Flex, Amazon Flex. They said they're full. They'll put me on a waiting list. And any other job I've been filling out for Indeed, I don't get a call back because of my schedule I'm a full-time dad. I mean, the mom doesn't help. Like I said, my grandmother passed December 1st. So that's the reason why I've been having a hard time with the job situation. And that's the reason why I'm going back to the motion hearing to talk to the referee once again. And Corinne Hale is here, also the mother of my child, who we are here for. And we have been trying to opt out of friend of the court services, but Heather keeps on saying that I have to pay this and pay this. And she's making it hard for us to get out of this situation because we don't need the help anymore.
Okay. Well, sir, in this case, she has testified that the mother is still receiving Medicaid for the child. You cannot opt out in front of the court if, in fact, there's public assistance involved.
We talked to her caseworker, and he's on her insurance, but it does take time for him to get off of Medicaid.
That's fine. I'm just telling you why it's still why it's still being addressed by the front of the court, so.
Okay.
Your Honor, can I just,
Yeah.
this is a good time to say this. I did tell him that he would have to pay over $2,000 some odd dollars for the confinement expense. That's another requirement, that confinement bill has to be paid before they can opt out as well. And I did give him that total balance.
Okay.
Thank you.
Okay. All right. So you filed a motion. You filed a motion with the court that was heard this Monday on the 15th.
Yes.
Okay. And were your taxes garnished this year?
Yes, my taxes were garnished to pay the last court hearing we just had like 2 months ago. That's the reason why we pushed it back to see if my taxes were going to get garnished. I called in a couple weeks later, and those were taken, like 800 and some change. I don't know the exact amount, but 800 and some change was taken.
All right. You said you are caring for an autistic child. Is that a child from another relationship?
Yes, from a different relationship.
Okay, and do you have full custody of that child?
I have full custody of that child.
All right, how many children do you have with Miss Hale, Corinne Hale?
One.
And how often is your parenting time with that child?
About around 50% every weekend and every time he gets a spring break or off day from school.
All right, so you're providing care for that child when you have them?
Correct, yes.
Okay. Are you currently employed?
No, I am not.
Are you filling out applications for employment?
Yes, I am. I filled out for Amazon Flex. That was the last employment I filled out for, and they reached back at me and said they would put me on the waiting list.
All right. How many applications per day would you say that you fill out?
I wouldn't say necessarily per day, but I would say like at least like 3 to 4 per week. I'm on Indeed.com filling out apps.
All right. How have you been supporting yourself?
Like I said, my child is autistic, so I get a SSI check from him, and I got Medicaid myself, and I receive food stamps around like $500 in food stamps.
Okay. Anything else you would like to tell the court?
No, that's all.
All right. Nothing further, Your Honor.
Okay, thank you. Sir, what's your education background?
It's high school. I had a high school diploma.
Okay. You, my understanding from the last hearing, you had testified that you had some CDL training. Is that correct?
Yes, I was doing CDL classes until my grandmother passed. Then it got hard for me to try to care for my son and go to school, so I had to stop the school. She was watching my child while I was doing the schooling until she passed.
You haven't paid since December 4th, 2023. Why is that?
Like I said, it's been hard for me being a full-time. Like she abandoned him like 3 years ago, so I've had him in my care for 3 years. Like I still see my kids, so I still take care of them while I'm with them. So, and then I was just assuming that I filed my taxes every year, that they would get the tax money every year upon, and that would clear the debt. That's why I'm like, why is the debt going up? And like, Corinne is here to agree with me that I do take care and help when I can for Logan, the child we are here for today.
Okay. Well, that's understandable, but you still have to pay on the support obligation. You can't wait until you get a tax refund once a year or something of that nature.
Yeah, I mean, I totally understand that, but it's just that, like, when I have him, I do provide. I buy clothes. I make sure he eats every day. I provide transportation. Like, I am providing for him at all times.
Understandable, and as a parent, you should be doing some of that, but that doesn't mean that you can ignore it the other times either.
Because it's like I'm basically paying twice, because I'm paying when he's with me. I'm also paying for he's in basketball, he's in football. I'm providing for all those things, and then I have to pay the courts, because Corinne Hale would agree that we don't want to do the court system. But like you said, it's all these other things I got to go through to get out of that situation. So I'm not trying to ignore the fact that I have obligations to pay, but I'm not going to say it's pointless, but it kind of is. But I understand the Medicaid situation.
Okay. Well, and in this matter, it's just so you know that you do get credit for the time that you have the child with you. And the reason you get credit for that is so that you can pay for those expenses when the child's with you. So contrary to what you said, you're not being double charged in this matter. You're being charged only for the days that the child is with the plaintiff in this matter.
But I still send money to the plaintiff if she asks for it.
And you shouldn't be doing that. You should be sending it through the front of the court, and then you'll get credit for that. Okay, anything else that you'd like me to be aware of, sir?
No, Your Honor.
Okay. Anything else, Mr. Sackrader?
I'd like to hear from Ms. Hale if she has anything to say.
Okay. And now, Ms. Hale?
I'm not sure what's going on with my caseworker. I have spoken with her a couple times, but I would not like to say this, but everybody don't do their jobs correct, even though they're supposed to. So I'm going to try to get back in contact with her as well today. But I definitely agree. I would totally like to just dismiss everything. I help him too with his kid. So it's starting to become backwards. I'm helping him out, so it's like, it's harder for him than it is for me. I make a nice amount of money. I can afford to take care of my child, and he helps me when he can, and he helps out a lot. So it's just, I feel bad that we have to just continuously go through this, but I definitely just want to wrap everything up. Even with the rearages, I would not mind forgiving them. We already got daily lives and debts and stuff going on. So this should just add more fuel to the fire. And then, so I'm going to try to get in contact with my caseworker and see what's the holdup. I know everybody don't do their job though, all the time. So
okay.
I've done my part on my end, and I've contacted her multiple times. So I'm just I'll figure out what's that so we can wrap this up.
Okay. Ms. Petrulio, are the arrearages owed to the payee, or are they owed to the state?
Hold on, let me look. There's $207 that's owed in MS, which is the medical portion of the support that's owed to the state. There is $560 through this month that is owed to the custodial parent. And then of course there's the confinement that would have to be paid. Yep.
Okay. And ma'am, that 560, it sounds like you're willing to you forgive that and cancel that. Is that correct?
Yes.
Now you understand you're not required to do so, and that if you do it, it's voluntarily.
Yep, that's fine.
And you understand you can't come back in once you've waived that, and we've in essence removed that. You can't come back and say, "Oh, now I want that back."
Yeah. Yep. I'm fully aware.
Okay. Well, as part of this, the court will order that the arrearage of $560 owed to the payee is in fact canceled and eliminated in this particular matter as a result of Ms. Hale's agreement on the record to do so. So that leaves us with the medical and the confinement expenses as well. Mr. Havard, what's your plan for taking care of this?
To be totally honest, like you said, we have this motion hearing on Monday.
Well, that has to do with your current support. It has nothing to do with the arrearage we're talking about today.
I'm going to try to pay what I can every month to get it knocked all the way down. I'm going to try my best, Your Honor.
Well, the history in this case is there's been a lot of adjournments, and I hate to do this, but I'm going to give you another adjournment for approximately 60 days, Mr. Havard, and I want to see what you're going to do in that 60 days. If you do nothing in that 60 days, then the court's prepared to have you go to jail. You understand?
Yes, yes,
so
sir.
You got to do something in that 60 days, or you're going to be incarcerated.
All right.
Okay. You're free to go. You'll get notice as to when that's going to be rescheduled, and we will talk to you back at that time.
Thank
All
you,
right.
Mayor. I'll adjourn that for, the 19th happens to be a holiday, so we'll adjourn it to June 26th at 8 o'clock. And just for the record, there is $112 owed in service and processing fees as well.
Okay. So we'll adjourn it to June 26th at 8 o'clock a.m. then.
All
Thank
right.
you, Connor.
Sanford versus
Okay, thank
Scott
you.
Sanford.
Okay. Good afternoon to both of you.
Good afternoon, Your Honor.
To the plaintiff, I note when I reviewed the judgment, I note that you took back another name. I know it'd be under Sanford. What's your current name that you go by now?
That's interesting. Sanford, the state bar says I have to practice under my quote unquote real name. So
Okay. I didn't want to call you Sanford if it was something else. That's all.
Yeah.
Okay. Well, this matter is before the court for an evidentiary hearing on the plaintiff's motion to show cause for a non-payment of various sums under the judgment and the settlement agreement. As I was reviewing this file, I would state too, unfortunately, I found that in Berrien County, you kind of don't keep your files the same way we do here. So it was very difficult to go through that file. Plus it noted that it didn't appear that everything was in the file that I got, but I think the salient parts were, I reviewed Judge Dufon's opinion and order from May 21st, 2018. And I note in his opinion, a number of things. First, at page 2, he states the parties agree that defendant has never paid the $100 per week specified in the settlement agreement for the purpose of food and groceries for the minor children, end quote. And then he states he asserts that while he did not pay the $100 per week, and then end the quote, it went on to state that he had contributed towards the lunches, etc. Page 4, it says the parties agree that the settlement agreement was placed on the record and signed by both parties. And in page 5, it claims that it was incorporated by reference in the judgment of divorce. Judge Dufon also held at page 7 that the $100 and the school lunch expenses were non-dischargeable in bankruptcy. And more salient in this point is that on page 9, paragraph 3, Judge Dufon states, plaintiff is entitled to a full 7 years and 4 months of the $100 per week payments for a total of $38,100 less any amounts that the defendant paid directly to the school for the children's lunches. I take it, and I note that going through his opinion as well, that many of the issues that Mr. Sanford, that you brought up today in your answer and your responses were already addressed by Judge Dufon. In fact, as I went through his opinion, he talked about the tax liens, the refinance of the property. He talked obviously for a long time about the credit reporting issues and the tax debt, etc. And he addressed all of those. So I guess based upon what I see, unless you're going to tell me that since that order of 5/21/2018 that you paid off the amount he claimed to be owing of $38,100, I guess I'm at a loss as to what we're here today on to argue, other than if you paid that amount.
well, Judge, the only issue that was before Judge Dufon was child support. In fact, the purpose of the entire hearing was to have child support set. He initially entered an order asking the parties to contact the front of the court and work through the front of the court to set a child support figure. The settlement agreement specifically indicates that if I didn't have the county contract, that I could have the child support issue readdressed, which is what I did.
Okay. Well, obviously, you and I are looking at a different opinion in order then, because as I read the order, he addresses, as I just quoted, many things. And in page 9, paragraph 3 states, plaintiff is entitled to the full 7 years and 4 months of the $100 per week payments for a total of $38,100 less any amounts that the defendant paid directly to the schools for children's lunches. That has nothing to do with child support, okay? And you may be engaged in some creative lawyering, but I see that as pretty clear in his opinion as to what he's talking about.
Well, I guess I didn't understand, Judge, because he made it clear that it wasn't support. that it, and he never described exactly what it was. If it wasn't support, was it property settlement?
Okay, well, I'm not gonna relitigate the whole divorce action in this particular matter.
Well, Judge, what I wanted to address today were the issues that weren't, which is that the settlement agreement specifically says that I was to get the minor child as a tax deduction for 2017.
Okay.
The plaintiff
Quite
doesn't
frankly, I will tell you, sir, that's not before the court today. The motion for show cause in this matter dealt with the monies that Judge Dufan ordered were paid. And Ms. Sanford, am I missing something here, or is that the substance of your motion, is that you were not paid the $38,100?
Yes, Your Honor, Judge Dufan did consider the child support. That is the motion that had been filed by Mr. Sanford. I responded to that motion with my own motion regarding the lunch or the grocery money. And yes, Judge Dufan heard all of it. The only thing that I filed was a motion to enforce that. And technically, it wasn't 7 years, 4 months, because the judgment was entered January 5th of 2010. It would be 2010, 11, 12, 13, 14, 15, 16, 17, and 18. And then 18 through my daughter's, our daughter's 18th birthday, which was another 9 months. So it was actually not 7 years, it was 8 years and 9 months.
Okay, well, I'm just going from his opinion to get a baseline as to what we're talking about. And I did note that you had brought up the issue that there were some additional times after that, but I'm going to his 2018 order in this particular matter. So
right. And then the school lunches, I can tell you, we had obtained like a printout from the schools regarding all three children, and we knew that number and know that number. That was $8,759.64.
okay, give me that again. 800.
$8,759.64.
Okay. Mr. Sanford, is that your understanding of the amounts that you had paid on the lunches?
That's the amount of that is the amount that's documented, Your Honor. I provided other cash monies, but I don't have a receipt for any of the stuff.
Okay, understand that. Now, Ms. Sanford, again, because this only took us through May of 2018, how many more weeks are we talking? How much more money before your daughter was 18?
So basically it was,
I would assume it's from June on, because he took through May 21st.
the problem is that he made just a simple math error because it wasn't.
Well, okay, I understand. I'm not going to go back and correct his math errors. If you want his math errors corrected, you go back to Judge Dufan, because I had no idea was it a math error? Was he thinking of something else? Was he giving credit for something that's not present or obvious in that opinion? So I'm not going to go back beyond his order of 5/21/2018.
So it would be from May until September 6th was her birthday. And I can, let's see, May, June, July, August, September.
Now, unfortunately, I don't have a calendar from 2018 before me, but you can probably find one.
I can try and go back here. What was the start date? May
21, 2018.
Okay. 14. 6, 7.
Sir, I'll have you look as well to make sure that you confirm the weeks post opinion.
15. It looks like 15 weeks. Let me just count one more time. 15 weeks and 4 days.
Okay. Well, if we take the 15 weeks times 100, that's an additional $1,500, which, if I add it to Judge Dufan's finding, would bring us up to $39,600. Sir, Is that accurate that it's 15 weeks?
Judge, I don't have any reason to dispute that. If
Okay.
it's not, it's close.
Okay. Well, and I guess I'll ask you, Mr. Sanford, is it accurate that since that order on May 21st, 2018, you haven't paid that particular amount, the $38,100, nor the 15 weeks after that?
That's correct, Your Honor. I did begin. Well, here's what the issue was, Judge. The issue was that I was still paying the mortgage. And so I wasn't financially able to make those payments until I finished paying the mortgage in December of 2018. And then beginning in January, I began making the $100 a month or $100 a week payments to resolve the other issues that we were mediating for, which was the tax credit for the 2017 that she just said I couldn't have on her own without any justification. I provided the court with what that cost was, and my exhibit list was $4,050 from the 2017 account. I had other expenses for things that I didn't get any credit for. Of course, it happened so long ago that I don't have any documents or proof or anything related to that, because typically I paid her in cash for it. So
okay, well, let me ask her, Ms. Sanford. I'm looking at the pleadings in this particular matter, and I note that as Mr. Sanford states, he acknowledges or states that asserts that from January 2019 to May of 2019, he did make 9 payments of $200 or total $1,800. Is that accurate?
He did pay $1,800. Yes, sir.
Okay.
That was attached to mine as well.
So with the addition of the $1,500 and the credit of $1,800, and I take it that the credit should also be for the school lunches of $8,759.64. Is that correct, Ms. Sanford?
That is the amount of the school lunches per spreadsheet. Yes, sir.
Okay. With that, it looks like the total would be $29,040.36 after that particular credit. Does that appear to be accurate?
yes, Judge.
Okay. Ms. Sanford?
I'm assuming your calculator is just as good as mine.
Okay, yep, I used a calculator because I wasn't going to freehand it and get the numbers wrong and have that issue be another point of contention, so. And I take it from what you've already said, Mr. Sanford, you didn't pay the $29,040.36.
I have not, Your Honor.
Okay. Well, I do note, as I reviewed this, that there were a lot of issues brought up, but as I said, I think many, if not all, those issues were addressed by Judge Dufan on the, in his opinion of 5/21/2018. So the only issue I see before the court is the issue of has payment been made or not made? And then I'll ask Ms. Sanford, what relief are you looking for at this time?
I am looking for that payment in a lump sum within 60 days.
Okay. Mr. Sanford, what's your position?
Your Honor, I don't have the ability to pay a lump sum payment. I would suggest paying it the $100 a week that the order indicates.
Okay.
This, by the terms of the agreement, Your Honor, this was grocery money. And I couldn't live with myself if I didn't express this to the court, whether it makes a difference or not. The argument that she's making is that she shouldn't have to comply with any of the terms of the judgment of divorce because I was simply able to take care of them all on my own. I went through bankruptcy. I took all of our joint debt with us so that we could maintain 2 separate households for the children. At no point during that bankruptcy action did she ever seek any of this money. I was paying her mortgage. I paid her car insurance. I paid her both of her vehicles off. I made all of the payments under the judgment. I did everything I was supposed to do.
Okay.
And she did nothing. She didn't come and pick her property up. And now she's saying, well, because your bankruptcy somehow magically made your financial responsibility for my mortgage to go away, I really shouldn't have to do anything. And my argument is the same, which is if the money by the terms of the judgment was for groceries, she was able to handle that all on her own. And there wasn't any need for me to make those payments. And she never asked for those payments. So I would ask Judge for
I understand that, sir, but as I state, Judge Dufan addressed all that when he had made that ruling back on 5/21/2018. He also addressed the issue of the tax debt and the liens. That was addressed before him on 12/18/2017. And also, I think at that time, he puts in his opinion, he states that in fact there was admission by you that in fact the Walla house was no longer on your credit report.
I never admitted that.
Okay, well, I have it in there. I have it in some of the paperwork someplace, and it's my understanding that it's off the credit report now. But notwithstanding that, that's not, again, the issue before the court today. We're talking about those particular monies that are owed in this matter.
Well, Your
But
Honor,
again, the court will note that, but again, that's those were issues that Judge Dufan addressed, resolved, and have taken care of. They're res judicata. The court's not going to go back and relitigate those issues at this particular point. What I'm going to do is based upon the credits that were provided and the additional amounts, the court is going to grant to the plaintiff a money judgment of $29,040.36. Plus, at this point, plus statutory interest, she can attempt to collect that. And should it be necessary and it goes unpaid, she always has the right to apply for writ of garnishment, writ of attachment, or writ of execution in this matter. So based upon what I heard, that will be the order and the ruling of the court in this particular case. Ms. Sanford, you can prepare that judgment, submit it to the court under 7-day notice of entry, and that will conclude this matter.
Judge, I filed a counter motion for contempt because she has not refinanced the house as ordered, as we agreed to in the judgment. She hasn't complied with that. She was supposed to do that on January the 1st of 2019, and she didn't do that.
Well, I want to get this matter resolved at this point. Again, if you can file a separate motion in that regard, the court will address that at some later hearing should it be necessary.
Well, Judge, I did file a motion, and that's why we asked for a contested hearing so that this all could be addressed at once. I filed my own motion for order to show cause for her non-compliance with the terms of the judgment.
Well, I have before the court. This is what I've received from.
I have an answer for her from that.
Okay, I understand the answer. This is what I have from Berrien County. First, the motion for order to show cause why defendant should not be held in contempt of court. To that, after that, I received a answer to motion for order to show cause. Then I received a plaintiff's reply to answer to motion for order to show cause. Then I received from defendant a supplemental answer to motion for order to show cause and plaintiff's reply answer. And then I have plaintiff's answer to defendant's motion for an order to show cause. I have no separate motion for you on show cause, sir, based upon what I've received. And again, that's why I stated I have issues.
Christie says that the motion is in the file on a sticky note.
My staff said we may have that, sir, but I'm not. I can't locate it in my review of the file in this matter.
So you have her answer to my motion, but you don't have my actual motion?
She's coming.
I went through what I had. Answers, replies, but no motion to show cause by defendant.
defendant's affidavit promotion in order to show cause versus order to show cause. Wonder if I have attached to.
But there's no motion. Well, at this point, sir, what, again, I'll stay with what I've said is, I read off what the pleadings are that the court has. I don't know that, if it was included with something else or not, I don't have any motion, so the court will not address that, at least on today's. You can file that motion, the court renotice it up, and we'll address it at that particular time, because quite frankly, because that wasn't, a pleading that the court had to review. I didn't,
Defendant's motion for order to show cause, I have it right here.
I don't have that, so I'll simply ask, sir, that you would renotice that up, refile that so that we have that, and then we can take up that issue. Then the court would have opportunity to properly prepare for that issue before the court. I don't want to, at this point, I want to just give you an off the hand or a less than prepared response, so.
Well, Judge, it's not complex. I mean, the issue is that she was supposed to refile.
Well, it's not complex, sir, but I want to go back to the settlement agreement. I want to go back to the judgment. I want to look under Judge Dufon's opinions to see if it's addressed in there, just as I did with her motion. So I want to give you the full benefit of.
There.
Okay.
It's titled.
We do have the motion for order to show cause, so we did find that now. Well, staff found it, I didn't find it. But again, I don't want to short shift or short change you, sir. What I'll do is have you renotice it. We'll address it at that particular time after I've had opportunity to properly review the file in full, just as I did with Ms. Sanford's again motion. So sorry that got missed, but with all the paperwork coming in from Berrien, it did. It just got missed, and I didn't want to again address that at this point without having a full preparation.
Your Honor, would the court like me to file a motion for installment payments on this matter, or would the court like to hear that?
That's up to you. I've given her a money judgment for that amount. You can file anything that you need to file in regard to that. And then file, well, we have that motion, so why don't you renotice it for a Monday. Well, I'll do it this way. I don't want to go through a motion hearing that. Contact my office, and what we'll do is we'll set this back up for another Wednesday afternoon hearing after we've had a chance to prep it.
Judge, I will try to file a motion for installment payments, so perhaps we can address all these at the same time.
We could do that. Just get everything in and renotice your motion as well.
But I don't need to refile the motion, correct?
No, we've staff was able to find it, so we've got it in the file. Just renotice it with any other motions you feel you need to file.
Okay.
Okay.
All right.
Thank you both, and you have a good afternoon, and we'll end this matter at 1:58 p.m.